Hello and welcome. This is our video for the Constitution Day 2021. As usual, we have John Aughenbaugh, Associate Professor in the Political Science Department, and Carolyn Eastman, Associate Professor in the History Department, who are here to talk to us about a constitutional issue. And so we decided this year we would also combine with the 20th anniversary of 9/11. So we're going to touch on a lot of topics, which Carolyn is going to introduce for us. And then I have bunches and bunches of questions.
Okay, so I thought I would start with, one of the most famous quotes from a US president in all of American history. The only thing we have to fear is fear itself.
Except you didn't say it with the accent.
So all of you will probably remember this is Franklin Delano Roosevelt, and it was delivered during his inauguration to the presidency in 1933, in the depths of the Depression. And we see that line repeated over and over and over in American life to sustain our courage in really hard times. But we have to remember also that the US has faced terrifying moments in American history. I mean, war, both international war and civil war, terrorism, both domestic terrorism and foreign terrorism, the threat of authoritarianism from Hitler to Soviet-style communism to threats to our right to vote. And of course, as during the Depression, extreme economic hardship, as well as disease that we're seeing today. And just as often in American history, we find that our fears at times have outweighed our dedication to constitutional principles. And I think the aftermath of 9/11, that was a terrifying time, but it was not the first time that we had suspended our civil rights in the face of a crisis. The thing is, there is nothing scared people won't do to stop being scared, and they will try to do that to somebody else. And I think that's a lot of what we're going to be talking about today. During the aftermath of 9/11, Russ Feingold, who was a US senator and actually the only senator to oppose the passage of the Patriot Act, which we'll be talking about today, said that we have to examine every item that's proposed in response to crisis to be sure that we're not rewarding the terrorists and weakening ourselves by giving up the cherished freedoms that they seek to destroy. I think that in a lot of ways, these questions about the Constitution and our civil rights are really important in times of crisis, if not more important during times of crisis. And so just a quick spiel here to remind ourselves of what the Constitution did. I mean, the Constitution lays out, of course, what the federal government can do and how we do it. So how do we elect representatives? What can the president do? How does the Constitution create a balance of powers? But it also lays out what the federal government cannot do. The government cannot infringe on your right to free speech. It can't infringe on your right to the exercise of religion. It can't establish a state religion. And so, of course, as we know, many of the amendments to the Constitution explain clearly what our civil rights are. The Constitution especially wanted to restrict the government in acting arbitrarily against its citizens. But again, then what happens in a crisis? What happens in a national emergency? Can we actually suspend part of the Constitution if we fear that it makes us vulnerable in a crisis? And so I think what we're going to be talking about today is what happened as a result of 9/11? What did we do with regard to the Constitution? And how does that have a longer history that we need to know about?
Thank you, Carolyn. That's perfect. That's a perfect, if anybody has a TLDR, that's it. And you mentioned the USA Patriot Act, and I want to ask Augie about this, because one of the reasons that I know what I do know about it, there's two reasons. One, I have a master's degree in Homeland Security and Emergency Preparedness, but also I'm a librarian. And the Patriot Act specifically talked about libraries having to turn over records when asked of people's searches, because they were trying to see if they could sort of control that. And it sort of seemed like it added new layers of surveillance. Is that right, Augie? Did it add new layers of surveillance to American society?
Yeah, one of the more notable features of the USA Patriot Act, and this actually ties into Senator Feingold's statement that Carolyn mentioned in her opening remarks. The USA Patriot Act gave the federal government, explicitly the executive branch of the federal government, the authority to engage in what we now refer to as enhanced government surveillance. So NIA gave the example of federal agents could go to libraries and explicitly ask for search records of their patrons without getting a search warrant.
Which, by the way, libraries took great pride in putting up signs that said, in the last 180 days, we have turned over no records to the FBI. I mean, it was a whole thing for librarians because we believe in privacy.
Okay.
What you search, what you check out should be nobody's business.
Yeah, because the goal of libraries, or at least one of the goals of libraries, is to encourage people to search out new knowledge, right?
Right. And if you think that somebody's going to tell the government what you're doing, you might be less likely. That might chill your research efforts.
That's right. But there are other examples or other tools within the USA Patriot Act. Another noteworthy example was the use of national security letters, where the government could send a letter to a business and ask for the business to turn over its records of its customers. Now, could the business reject or turn down the request? Sure. But post 9/11, where patriotism, was at fever pitch, very few businesses actually turned down such requests. And the national security letter did not have to be based on any provision of the Fourth Amendment. So when we talk about government surveillance, the constitutional amendment, and again, this ties back to Carolyn's introductory remarks. If the government is investigating a domestic crime, did NIA, for instance, engage in criminal activity? Did the police receive a tip that suggests that NIA engaged in a criminal act? The Fourth Amendment's provisions would be applicable, meaning that an unreasonable search, would force law enforcement to go to a neutral judge, demonstrate probable cause, and then the judge would issue a search warrant. So the Fourth Amendment, again, much like Carolyn mentioned in her opening remarks, the Fourth Amendment would place burdens on the government, make it more difficult for the government to exercise its authority to investigate crime. But what if the purpose of the government search is to protect the nation from future terrorist attacks, or other, for instance, nation states that may want to engage the country in a war? At that point, the Fourth Amendment and its protections, at least according to the United States Congress, and for that matter, the United States Supreme Court, does not have as much bearing. Because in the 1970s, the United States Congress passed the Foreign Intelligence Surveillance Act, which allows the government to go to a secret federal court and get a search warrant that does not necessarily have to be based on probable cause to go ahead and surveil, search those individuals who might be enemies of the state.
And we're not going to get into it here, but the FISA courts, which is what you're talking about, I believe don't ever turn anyone down, or their turn down rate for a search is like 4% or something. It's a very low bar.
It's less than that. According to scholars, the FISC, the Foreign Intelligence Surveillance Court, in its existence, has turned down less than 5 warrants, FISA warrants requested by the federal government.
And one could argue that there also, I mean, that there may be higher standards to get there to start with, right? That you have to actually show that this person really is a danger. But it goes to Carolyn's point of fearful people will do a lot of things to not be fearful, including stomp all over individual rights to say, but it's for the protection of the country, right? Like,
and this is
I really need Nia's records because I think she's an international terrorist of intrigue, which, by the way, I am not. But if they thought that, they would be protecting you and Carolyn from me, right? Like they would be protecting the rest of the nation from me, which lends legitimacy to that question and brings into question the whole idea of, what is it Franklin said, when you give up safety for security, you get neither, right? Like it's a
well, yeah, and in one of the themes, at least of my remarks, for our discussion of the Constitution post 9/11, is that this ties into something that we've seen throughout our country's history, which is the tension between the government exercising constitutional authority versus individual rights and liberties. And I think that both Carolyn and I will touch upon this in the next few minutes, because it is a tension. One of the more infamous quotes, and a number of Supreme Court justices have said this, and a number of federal judges have said this, is that the Constitution is not a suicide pact, right? It's not a suicide pact, right? I mean, the three of us logically could go ahead and develop a hypothetical situation where the maintenance of individual liberties could harm the nation. On the other hand, how far do we go in allowing the government to protect the nation when, as Russ Feingold mentioned, in so doing, we harm the underlying principles and values of the U.S. Constitution?
Right. And I just remembered that Franklin quote is actually wrong. It's those who would give up liberty for security get neither.
Neither, that's right.
It's liberty that he was after, not safety. I suspect because in his world there was no such thing as a worry about safety.
But, well, I mean, if you think about it, after the Revolutionary War, for instance, it wasn't like the new nation was extremely confident that it would continue as a standalone nation state, because they were quite aware that other nation states would like to go ahead and take back the land that was the United States of America, right?
So, but I want to ask you about something else.
Okay.
If it's okay.
Sure.
So I don't want to get too deep into things like waterboarding and stuff like that, but we engaged as a nation in sort of personal torture in order to get information. Or, well, torture is a heavy word and I probably shouldn't use it because it's biased, but it's how I view it. It's how I view it now and it's how I viewed it then. But but we sort of said, if this person knows if there's going to be an attack, we need to glean that information in some way. Is that, is it just me, or is that controversial for everyone? Because like, it's really hard in my head to, I mean, there's a part of me that's like, yeah, if you know there's going to be, if you're responsible for something, I want to know if it's going to happen so I can try to stop it. But the other part of me says, I don't think it's good to half drown people, like, ever, because then it puts me in a moral weak position of how can I say that I'm better than somebody who would do that to someone else. So has that been sort of a,
Well, yeah, I mean, this was what you're referring to is what scholars and those in government refer to as enhanced interrogations. Enhanced interrogations. And again, the dichotomy between what the government can do in investigating domestic crime versus something like terrorism or a national security threat really highlights the tension that I just mentioned a few moments ago. Domestically, when law enforcement want to question you, the Supreme Court's ruling in Miranda versus Arizona is applicable. The government has to remind you of your rights. Okay.
they can lie to you,
Sure,
but
they can.
but they have to tell you that you
You
have
have
the
the
right
right to
to
remain
stop.
silent, et cetera, et
You
cetera,
have
et
the right to
cetera.
an attorney.
Yeah. Okay. If you cannot afford one, one would be provided for you.
Yeah.
You should be aware that anything you say to us may be used against you in a court of law. So it's designed to protect you as an individual. But, you know, what if the government's questioning of you is not necessarily for protecting life, liberty, or property, which is found in the Fifth Amendment of the US Constitution? What if the purpose of the questioning is to find out, as you just mentioned in your example, okay, do you have information about a future attack on the United States nation? Do you have any rights? Okay. And this became quite controversial because the Bush 43 presidential administration issued legal memorandums that would justify enhanced interrogation, including tactics like waterboarding and other forms of torture. So again, this happens after 9/11, right? This happens after 9/11.
Although we should remind people this does not happen physically in the United States.
Well, yes.
This is a rendition issue where we take you somewhere else to do these things to you, just in case it turns out our memorandum are wrong and the courts find against us. We'd like for you to not be on the physical property that is owned by the United States.
Well, and this actually brings us to the third example that I wanted to mention, which is the writ of habeas corpus. This is known as the Great Writ. Okay, it flows from British common law and the Magna Carta. The writ of habeas corpus is basically a document that an individual can submit to a court where the court forces the government to explain why you are being detained. Okay.
Habeas corpus,
Okay.
body, holding of the body.
Yes, right. Holding of the body. Okay. The government has to explain why you are being detained. And Nia, you just mentioned rendition. Well, post 9/11, in the global war on terrorism, the United States government made a very quick decision. Okay, in 2003, it was going to detain either material witnesses or individuals that they suspected were involved in terrorism against the United States. These individuals would be detained outside of the United States, because the argument made by the Bush 43 administration was, if they weren't being detained on US soil, then any habeas corpus protections afforded individuals in the United States in regards to domestic criminal activity would not apply, would not apply. And the US Supreme Court tried to really thread a very small needle with a series of rulings, two of which were in 2004 and another of which was in 2008. In 2004, it was Hamdi versus Rumsfeld and the Rasul cases, where the Supreme Court said that individuals that were detained as part of the federal government's global war on terrorism must be given some due process, not full due process that you would see in a criminal trial on US soil, okay, some due process. But in the Rasul case, they said that individuals should have access to the writ of habeas corpus, even if they were detained, as we come to find out in 2008, in the Boumediene case, even if they were detained at Guantanamo Bay, because legally, the United States does not have possession of Guantanamo Bay. That's the possession of Cuba. And that was
Guantanamo Bay is like our timeshare for prisoners, right? We don't own it, but we keep up the property, and then we're allowed to keep people there.
And as in the narrow majority of the Supreme Court held, legally we don't own title to Guantanamo Bay, but functionally we have controlled it. Since Carolyn, correct me if I'm wrong, the Spanish-American War.
Yeah.
Okay, so habeas corpus does apply, but the process, due process, is not the full-bodied version that you get in a criminal trial on US soil, okay? It's something in between what the government wanted and what individuals who are being detained, okay, abroad by the United States government.
So you mentioned this as a function of the war on terrorism.
Yes.
But I would like for us to perhaps get into some historical examples, and I know Carolyn can help us out with sort of the war on war, right? Like, sorry, the actual, what we think of as traditional war, or as I like to think of it, how American history is taught, right? Because we had the Revolutionary War and then nothing happened, and then we had the Civil War and then nothing happened, and then we had World War I and then nothing happened. And Carolyn can disabuse us of that notion because lots of things happened between those things. But that does tend to be how we teach it in high school. And I know that in the Civil War, there was an issue with habeas corpus.
That's right.
But I know there are other historical examples. So Augie, can you address the Civil War example? And then Carolyn, would you be willing to address sort of the other, what I think of as regular war examples? And then maybe we can talk about the difference between a regular war and a war on an idea, and whether those have whether there's a tension there or not, because I suspect there is.
Yeah, and I think this is a really good segue to some discussion that Carolyn wants to get into. One of the issues during the Civil War was that the Lincoln administration wanted to give military officials on the ground the ability to lock up individuals who might either participate for the Confederate side of the Civil War or who were sympathizers for the Confederacy. And Lincoln, at least initially, President Lincoln, at least initially, went ahead and gave his field commanders the authority to suspend the writ of habeas corpus. And in the case of Ex parte Merryman, a federal district court that was being chaired by Chief Justice Roger Taney of the US Supreme Court held that Lincoln did not have that authority. that only the United States Congress in Article 1, Section 10 could suspend the writ of habeas corpus. Okay. Now, Lincoln went ahead and completely ignored the court's ruling against him, and then gave a speech in front of Congress, okay, where he asked for Congress to suspend the writ of habeas corpus. And it was the infamous all laws but one speech, where Lincoln basically gave a justification that we've heard future presidents actually make in wartime, which is better that one law, one part of the Constitution be ignored than have the entire Constitution brought asunder because the US lost a war. And we see that kind of logic, and I think Carolyn's going to touch upon this a little bit. We see this kind of logic, okay, throughout our country's history. I mean, it is truly remarkable, okay, how much, okay, we have seen this historically.
That's right. And I mean, it's a tragic moment, really, in American history when Lincoln did that, because he was a lawyer. He was steeped in constitutional law. He had based his run for the presidency, his early presidency, on the idea that he was out to save the nation and be dedicated to the principles of the Constitution. But again, this was one of those cases when you had this national emergency, and he felt that he was weighing, on the one hand, the saving of the Union itself with the dedication to our constitutional democracy. I mean, it's a really striking moment.
But it's not the first one, right? It's not even the earliest.
No,
Is that?
No. And I mean, this is something a lot of us remember, I think, from our high school civics classes, our history classes, that during the period of trying to ratify the Constitution, when all the different states were holding conventions to decide whether or not to support this new federal Constitution, one of the things that really held them up was the Bill of Rights. There was no Bill of Rights in the initial Constitution, and anti-federalists in each of the states opposed the Constitution because it lacked that dedication to preserving individual rights. Things like the right to free speech, the right to bear arms, and so on. And in fact, James Madison, who is one of the key architects of the Constitution, really thought that the Constitution didn't need a Bill of Rights, or this is what he thought initially, because he said that those rights could be so easily suspended in a time of crisis. And we've seen that he was right. I mean, I've been going over this material, and I've ultimately found maybe two big categories under which the US at different times has suspended aspects of individual rights. And one was a category of moments in American history when they feared speech, and another is moments when they feared people. And those seem to be two key things. And I can talk about maybe, what do you think, Nia? Should I talk about the fear of speech first?
Yes, please.
Yeah.
Well, and this is apt, I think, because it relates to 9/11. There was a lot of talk about sedition after 9/11. There was a lot of talk about maybe the need for enforcing certain kinds of support of the federal government and the US military and so on. But this goes way back in American history. The fear of sedition, that is, sedition meaning, of course, outright criticism or questioning of the US government and its actions. It goes back, really the first time it appears is in 1798 during the President John Adams administration, when the US was involved in really a quasi-war with France at this moment. And more broadly, there was a really enormous fear that this new fragile United States would either be, enfolded into another international power, or that the US would experience the same kinds of violence and chaos that had really racked the country of France after the French Revolution. And so Adams and his administration were so nervous about the quasi-war and about the fear of chaos and violence that they passed the Sedition Act of 1798 as part of a number of other acts designed to protect US security, basically. And you know, the argument was that you needed a law to oppose speech that criticized the US government and its actions, because that would strengthen national security. But this was incredibly controversial. You know, Adams was a Federalist, and his opposition in the Democratic Republican Party, like Thomas Jefferson and James Madison, they argued that in fact this was destroying some of the security buttressed by the US Constitution. It wound up leading to the jailing and fining of a number of newspaper publishers, in particular, newspaper publishers that were affiliated with the Democratic Republican Party, but also who simply criticized the Adams administration for its actions during this period. So, you know, they ultimately suspended it after Thomas Jefferson was elected president in 1801, but it was an enormously controversial law that really called into question whether Americans really had the right to free speech, whether they really had the right to criticize the government if they wanted to, or does the government have the ability to suspend that right of free speech in a time of crisis?
Yeah,
and
I'm of the opinion you should be able to say the president is a fink. Right, like the old comic strip, the king is a fink. You should be able to say that, and you should not be called a not patriot if you still want to call them French fries and not American fries or whatever, like, which we got after 9/11. We got after 9/11. One of my favorite bands, the Dixie Chicks, said, "We're sorry the president is from Texas," and radio stations stopped playing their music, and they were seen as not patriotic. And there was all this, because they weren't supporting the war in Iraq, they were sort of banned from the airwaves for took a long time for them as a band to come back. And that's the kind of thing you're talking about. That's infuriating.
Exactly.
And the radio stations, for instance, not playing the Dixie Chicks. Okay, that's, you know, that's, again, that's protected, right? But there were actually bills, okay, in various state legislatures. Right. And that's where the First Amendment would have kicked in, right? I mean, because if a radio station makes a business decision not to play a certain band's music, well, I mean, hey, you know, they could lose listeners, which hurts their ad rates, et cetera, okay? But that's protected, right? But what if the Texas state legislature had passed a law, okay, that banned the playing of Dixie Chicks music on radio stations in Texas? Now the First Amendment kicks in, right?
That's right.
Okay.
Carolyn's, oh, sorry, go ahead.
Well, this idea of speech, I mean, it wasn't, and that experience, Carolyn, wasn't the only time we have seen this, right?
That's right. That's right.
I mean, World War I was, for me, just utterly fascinating, okay, in regards to the attacking of speech in the lead up to the U.S. participation in that war.
Yeah, and in fact, I mean, I think that it's a really striking thing, and I mean, we can go back and forth about this. So, during World War I, in fact, in 1918, the U.S. was sort of deep into its involvement in World War I, and the administration of Woodrow Wilson at that point passed a Sedition Act in 1918 that severely curtailed citizens' right to free speech during a time of war, because Wilson felt that US morale during the war was flagging, right? I mean, he wanted to clamp down on criticism of the war, complaints about the draft, and so on. And so he actually wound up making a list of the things that people could not discuss lest they incur the wrath of the US government and get thrown in jail, right? So they couldn't, newspapers, people in the public couldn't talk about disloyalty within the military. They couldn't criticize the government, the Constitution, the draft. They couldn't engage in labor strikes that involved in the production of war materials. And they couldn't express support for countries that the US was at war with. I mean, so this targeted people like pacifists, and other people who had, religious and other moral reasons for opposing the war. And the punishments were extreme. You could get up to 20 years in prison. You could get a fine of $10,000. And there were more than 1,000 convictions during this period. It was an extreme sort of restriction of free speech during a time of war.
I would be arrested now.
Right.
If that were the case. I complain about the government all the time.
Right.
And
Well,
I do it in a loving way, right? I want it to get better, so I say things, but I mean, goodness, 1,000, I didn't realize so many people had been arrested in what we think of as modern America, right? Because I think most people think post 1900 is sort of modern America when you get into World War I, World War II, and you're talking there about you can't say things, like you just can't even say things in public without being arrested. That's terrifying.
Right.
Nia, during this period of time, the law that Carolyn just mentioned gave the Postmaster General of the United States blanket authority to decide what publications could be mailed. And if he thought that they harmed the US war effort, he had the authority to stop the mailing of those publications.
That's enormously powerful and very scary, because
Sure.
if you can't, I mean, I assume that intellectuals went underground, right? Because they were going to be arrested if they were publicly saying, let's talk about whether this is a just war or a fair war, or whether we should be involved or not. Not even picking sides, but discussing it, I assume, was enough to bring out the question of whether you were being loyal or not.
Right.
And it was during this period of time that the U.S. Supreme Court took a case that challenged the Sedition Act, the infamous case of Schenck versus the U.S., where the U.S. Supreme Court, in a 9-0 vote, came up with the clear and present danger test. If the government could show that one speech would create a clear and present danger that the government had the authority to stop or prevent, then that speech, did not garner First Amendment protection.
That's scary.
It was truly scary. And again, it was in that, in Justice Oliver Wendell Holmes' majority opinion. He made it very clear that what was acceptable constitutionally protected speech in peacetime was not necessarily constitutionally protected speech in wartime.
That's right. And, this seems so extreme, but these kinds of discussions didn't end. I mean, during the President George W. Bush administration, there was talk about reviving a Sedition Act. There were all kinds of non-governmental efforts to sort of tamp down on speech that criticized the government, criticized the United States. And then, just in the past 4 years, we've seen a lot of criticism of the media for criticizing the government, criticizing the president, and so on. So, I mean, these discussions about what we can do as individual citizens, but also as media outlets to criticize what's going on in the government, these are ongoing discussions. And the question of whether that ability to speak freely is still guaranteed in times of crisis, these conversations continue.
it's an interesting question to me what those leaders would have done with the interpersonal media that we have now of Facebook and Twitter and TikTok. Like Wilson's hair would have fallen out in clumps, because you talk about a way to reach people extra governmentally, right? Because that's outside theoretically, although you bring up the question to me of could the government shut down Twitter if it thought that Twitter was encouraging sedition? Could that be a thing that could happen in war? That's really scary. Thanks, Carolyn, for giving me something else to worry about at night.
Well,
You're welcome.
But again, this touches upon one of Carolyn's central points, because shutting down media, and in particular of recent vintage social media, is what we see in authoritarian regimes that don't have a strong constitutional history or regime. Okay.
Right.
So yeah. So I mean, so if you think about it in those terms, you know, Carolyn and I give talks all the time, and sometimes we have audience members who are like, you know, you guys are, you know, talking as though the sky could be falling, right? You know, you're exaggerating the threat that is posed when the government does X in a crisis. But then when you compare what the United States government has contemplated or has actually done with authoritarian regimes without strong constitutional rights, norms, then you're like, this is the danger. Okay, this is the danger. And you know, probably the classic example of this, and this is not so much about speech or press, but it's actually about people. Carolyn, occurred during World War II.
That's right. That's right. In fact, yeah, like I said, I think I've sort of created these two big categories of, on the one hand, we've seen instances of the fear of speech suspending our constitutional rights, and the other is a fear of people. And I think that there are two really strong examples here. I'll just talk about the first one, which is the famous internment, but really incarceration of Japanese Americans, people of Japanese descent during World War II. So this discussion really began with the bombing of Pearl Harbor, when President Franklin Delano Roosevelt, you know, the very man who told us not to fear, signed Executive Order 9066, which placed about 120,000 people of Japanese descent into internment camps during the war. It also wound up placing about 14,000 people of German or Italian origin into internment camps. So it was not entirely about the Japanese, but the Japanese were thrown in such huge numbers. And the Japanese were the only people where something like 2/3 of the Japanese Americans incarcerated during the war were American citizens. They were native-born American citizens, and many were mixed race people. So, you know, the US government defined anyone who was at least 1/16 Japanese as Japanese American, and therefore suspect, you know, thrown into camps. And so, you know, this incarceration happened because Americans let their fears overpower their reason and all the evidence. I mean, the US should have known better than to enact this order, because they had actually been undertaking different studies of Japanese American loyalty to the United States. They had studied this question in 1941, right before Pearl Harbor. Researchers had not only confirmed that Japanese Americans were, you know, extremely unlikely to be disloyal to the United States. And in fact, they found what they called a remarkable, a quote, remarkable, even extraordinary degree of loyalty to the US. And then in a subsequent a study in early 1942, they also found, US researchers again found very little evidence to support all these hysterical claims that Japanese citizens, especially, Japanese American US citizens on the West Coast might commit espionage against the United States. But, you know, this was one of those periods when the anxieties about large-scale attacks on the West Coast in particular, combined with a really profound and long-standing anti-Asian prejudice, especially again in the Western states, it just led to this sort of willingness to ignore the evidence and act on their fears. And the US government, the Supreme Court supported that until a 1944 decision that stated that loyal citizens of the United States could not be detained without cause. So it really wasn't until 1945 that the Roosevelt administration rescinded that order. I mean, this was a period when it wasn't just that, you know, 2/3 of the Japanese Americans in internment camps were US citizens, but about 1/4 of the total number of people in those incarceration camps were children. And I mean, it's a really remarkable thing that has been so thoroughly condemned after the fact that in 1988, President Ronald Reagan agreed to essentially reparations. He granted $20,000 to each internee at that point. $20,000 in 1988 is equivalent to about $44,000 in 2021 dollars. And in 1991, I think, President George H.W. Bush issued a formal apology for that act. It's an extraordinary period of time when all of a sudden people were so afraid that they were willing to ship people into camps rather than live with the anxiety of possible espionage by their neighbors.
Well, and not to put too fine a point on it, but Japanese Americans were easier to find because of racial differences. Right. It was much harder to find German and Italian criminals than it would be to find Japanese American criminals because, right. And,
well, and but really, you cannot understand this period without understanding that anti-Asian prejudice, especially in, you know, California, Oregon, Washington, that had been a very ugly stain in American history going back to the mid-19th century. So the anti-Asian aspect of this prejudice against Japanese Americans was profound.
I, first of all, am completely appalled, right, like everybody else. But I also think that we kind of skim over that historically wise. It's not something that gets talked about a lot, that we did a thing that we condemn Germany for doing. And while we were not killing people in the camps, we were doing just above that. Like everything, like the conditions were terrible, and it changed people's lives in ways that are still ongoing in those families. So,
well, and you know, I have to say, I grew up in California, and a lot of my best friends were they of course had not been, they were too young to have lived in the camps, but their parents had lived in the camps when they were children, when they were teenagers. And when I was in high school history classes, none of this was even taught. It was an amazing moment of just ignoring it. But the people I grew up with in a very agricultural part of California talked about the fact that when their families were shipped into the camps, their land was stolen, their property was stolen, their houses were taken. In some cases, people tried to ask a neighbor to look out for their farmland or their business or something, but often it was really hard to get that land back, or it was mismanaged, or it was sold out from under them. And so the history of the not just the incredible insult of being a US citizen and being thrown into a camp as a suspected terrorist, effectively, but then also the longstanding property and material damage to your family's wealth, to your family's ability to survive. It was a profound thing.
Yeah, it was a complete evisceration of a series of constitutional rights for Japanese Americans, right? I mean, it wasn't just that they were not given due process or that they were not treated equally under the law per the 14th Amendment. As Carolyn just mentioned, even after the war, they had nothing to return to, right? Because the takings clause, okay, was completely ignored. Their property had been taken, okay? I mean, if there was a bedrock, if you will, agreement among the constitutional framers in Philadelphia in 1787 was, okay, the sanctity of property.
Right.
Yeah, I mean, it was completely eviscerated.
I want, if we can, because that infuriates me, so I would like to move on to something slightly less infuriating, if that's okay with y'all. And that is this sort of, Carolyn, can we talk briefly about going to that sort of war on ideas and people, which is this sort of McCarthyism, communism, Reds under every bed, right? Like, and dragging people through the mud and destroying careers and destroying lives by accusing people of intellectual disloyalty or political disloyalty.
That's right.
To the American government, which we see just after World War II. So clearly we didn't learn anything in that time. Right. We were like, wait, hold my beer. I can do something else dumb, right? Like I can do something else that's crazy and removes people's rights and all that other kind of stuff, because some people were accused and there was no proof. Like they just were dragged through the mud with no proof. What's that about?
Yeah, I mean, after World War II, the spread of communism, not just in the Soviet Union, but also beyond, led to real fears that communism would extend to the United States and threaten constitutional democracy. And so even in 1947, President Harry Truman was calling for loyalty reviews of governmental employees. I mean, at this point, the hysteria about communists maybe having infiltrated the government, infiltrated positions of cultural power, just began to sort of snowball. And I mean, imagine having your loyalty called into question. I mean, imagine facing an employer who demanded that they have the right to scrutinize anything in your background for any indication of your being a communist sympathizer or some kind of perceived disloyalty to the US. I mean, some people were found to have had membership in a communist organization, maybe going back to the 1930s, when membership in communist organizations was rampant in the US. It was not seen as a major problem in the 1930s. But in the late 1940s and 50s, I mean, a number of federal employees quit their jobs because of principle, because they objected to this kind of extreme scrutiny of looking at any sign of disloyalty. But it could also, becoming a kind of a witch hunter could be an incredible political move. And so we most famously remember the Red Scare for Senator Joseph McCarthy. I mean, he was the one who came out starting in 1950 saying that he had lists. He would famously hold up a piece of paper and say, I have a list of known communists in government. And, at one point he said there were 205 people on that list. At another point, he said there were 57 people on that list. Anyway, but he's the one who really had a starring role on the House Committee on Un-American Activities, or HUAC, as it was called, the acronym. I mean, this was, of course, the famous site for these kinds of interrogations of people, much like a trial, really demanding that people either confess to having some kind of background with communist sympathizing, or that they name the names of people they thought were possibly communists. I mean, it's no wonder that this was exactly the period when the playwright Arthur Miller wrote his play The Crucible, which directly compared these un-American activities trials to the witch trials in Salem back in the 17th century. I mean, these trials went on for years. It stretched from 1950 to 1954, and Joseph McCarthy himself gained incredible political power as a result, as the kind of witch hunter in chief. And, you know, these trials didn't just try to ferret out people who might be communists themselves or communist sympathizers. It also tried to ferret out people who might be susceptible to communist blackmail, and therefore they posed a security risk. So McCarthy, actually, his committee interrogated two gay people, two LGBTQ people, which then heightened this growing sort of anxiety in the minds of the public that LGBTQ people might be especially susceptible to blackmail by communists because they quote led double lives. I mean, the thinking sort of went like this, that a gay person had to hide their sexual or gender identity, and that meant that they might wind up having a communist threaten to expose them lest, you know, they lose their jobs and so on. And so that meant that, you know, the federal government wound up removing something like 162 civil servants from, you know, who were suspected of being LGBTQ. Others were fired simply for being associated with LGBTQ people. So they were tarred with the same brush. And, you know, some of the people who were fired wound up committing suicide. It led to, I mean, you know, we often call this period the Red Scare, but within that, there's something that we've come to call the Lavender Scare. That is the fear of LGBTQ people, and people who already faced incredible levels of brutality by the police, from society. The communist hysteria of the 1950s just made this worse. President Eisenhower's administration ultimately fired at least 10,000 civil servants because they were suspected of what the administration called sexual perversion. And it affected the military too. It led to strong anti-LGBTQ bans within the US military. So, you know, this was just an extraordinary period of attacks and fears of other people, you know, within Hollywood. Of course, there were famous trials within the HUAC hearings of members of the Hollywood elite, writers, actors, directors, producers, and so on, for being suspected communists as well. So anyone who might have any kind of role within the government, but also within US culture more broadly, could be attacked, writers, etc.
Of course, one of the great ironies of these tactics was that the departments that typically had the most employees, civil servants, removed in the federal government were the departments responsible for national security.
That's right.
So you're talking about the State Department, the Department of Defense, but more specifically, the armed forces.
That's right.
That is one of the great ironies, if you will. By going after said individuals, we are actually harming the infrastructure designed to protect us post-World War II.
Yeah, and I'm reminded of one of the things that that people said after 9/11. You know, they often said that if we continue to suspend civil rights, the right to speech, the right to you know, various aspects of privacy, the terrorists win. And I think in a lot of these cases, you know, we were actually undermining national security because of our fears and our need to sort of buttress national security.
Well, and I feel certain that the KGB in its day used that, right? As booga, booga, booga. Even people who weren't directly in that web got caught up in a web, because if you gave names to people, then it would imply that they were somehow involved in something nefarious when they weren't involved in anything nefarious at all. So that whole hysteria, your enemies play into that by, by recognizing it and pushing all your buttons.
That's right.
So, the less hysterical you are, the less your enemies get a foothold in making even more drama. I know we're going to wrap up here, but I did want to say, it seems to me that we have a rather long history of thing happens, wild overreaction, tamp, back down to relatively normal. Everything goes along for a while, and then something happens and we have another sort of wild overreaction. I mean, we're going to inter people who have nothing to do with terrorism and who have high levels of loyalty. We're going to wipe out 10,000 employees because we think they might be communists. We're going to, do all these things. And then post 9/11, we did the same thing. So I'm going to put to you both sort of, if you can give me a relatively short answer. Is there hope? Are we learning? Are we getting better at doing this? Are the courts getting better at doing this? Or is this the next time we get slammed with some crazy thing? I mean, have we done the pandemic any better than we did 9/11? Have we been more circumspect about enemies or control? Or, oh, you're both going, Nia, why'd you ask this?
Well, I mean, in using the example of the pandemic, the U.S. Constitution was not written to address a pandemic. Okay, and I've tried to explain that to people on both sides, those who would like the government to be able to do more, and those who have actually resisted what the government has done so far during the COVID-19 pandemic. Nia, you've heard me say this. Carolyn, I know you're well aware of this. There's no fine print, there's no footnote or endnote to the US Constitution that says all of the above provisions apply with the exception of these events, right?
There's no asterisk
Yeah,
at the
right?
bottom.
So, something like responding to a pandemic, where on one hand, the government wants individuals to give up, if you will, certain freedoms, certain liberties, some of which are actually protected in the Constitution for the collective good, runs headlong into, one of the dominant features of US political culture, which is, you don't get to tell me how I go do X, right? Okay. And you can't punish me for actually questioning whether or not the government's claims that this vaccine works, or these masks work, or we should wash our food that we bring home from the grocery store, et cetera, et cetera. You can't punish me for freedom of speech. On the other hand, we know that unless individuals subjugate, change their behavior for the collective, we're not going to get a handle on this pandemic. We know this, right? And again, that runs into the logic of the government saying to individuals during wartime, you can't do X because we're trying to fight a war. We're trying to protect you. So I'm not entirely sure we learned all that much. Carolyn, maybe you have a different perspective, but.
Well, I just keep thinking about how, of course, for a lot of our students who are going to be watching this, they were born after 2001. And so they don't remember the extreme fear that we all had at that moment. I mean, and I don't want to say that fear is stupid. Fear is profound. Fear is, oh, absolutely.
It's tangible. Yeah.
And most of the
tangible.
time it keeps you alive. Like in terms of the animal kingdom,
Yes.
is that a lion? I should
Yeah.
run, right? Rather
Fear-
than, is that a lion? Ooh, let me go find out. No, your
Fear
body
or
is
flight, right? Fear or
right. Your
flight.
body is exactly. So
Yeah.
fear's not necessarily a bad thing. I'm sorry to interrupt you, Carolyn. You were saying-
No. This is really helpful because I think what we all remember is not just the fear that our city might be next, on an actual terrorist attack. They might fly a plane into our house, but also there was the fear. I mean, you remember somebody was sending letters with anthrax through the mail, and people died because of their exposure to anthrax. And so, I mean, there were a lot of things going on at that moment that were formative. I remember the profound feeling of fear and incredible uncertainty about what would happen next. And I think that, this is just my view this is about, the what I have seen over the past 20 years, which is that we have become a country that is punctuated by these moments of fear more often than what I remember about my life before that. I don't remember, for example, another moment when I got to an airport to fly someplace and really had to, I felt the need to be looking around, who else is on the plane with me, the way that I did in the immediate aftermath of 9/11. And of course, our experience of airports is a profoundly different one as a result of 9/11, right? And we accept all of the scrutiny of our bodies, of our bags and everything else as a result of that. We undergo that scrutiny for the safety of all of us on the plane, the same way that a lot of us argue that, wearing a mask is a small thing when you consider the greater good of all of us. But I think that what I've seen is the last 20 years have been punctuated by these extreme moments of fear more often than what I remember in my younger life. And I mean, that's just my own personal view. I'm not sure that anyone who really studies the 1970s, 80s, and 90s would say, look, the fear. But that's my view. And it worries me that the real goal, which is the greater good of all of us, is at risk if we continue to have these extreme moments of great fear.
I agree with you on a purely my memory, not scientific view, but I'd like to think that we are at least not, that because so many of us now have so much intercommunication, that maybe things won't happen secretly the way they have happened in our past, where only a few people knew what was happening and larger swaths of people did not. So I kind of have a hopeful view that even if we do have another horrible event, or when we have another horrible event, we will be able to communicate with each other because we still have all these sort of interpersonal communication, as I said before, with TikTok and Twitter and Facebook and just texting, right? Just texting people back and forth, which we did not have during 9/11. That was not as big. It had already come in, but not nearly as much as it is now. So I think that we are a mixed bag of hope, but caution. And that could just be because that's who we are as academics. We are cautiously hopeful.
Well, I mean, intellectually, Nia, I mean, to your question, there are certain patterns that Carolyn and I identified today that other scholars have identified that do kind of point to patterns of behavior that if we wanted to change or address, we could. Okay. And intellectually, I think we could. But back to Carolyn's point just a few moments ago, okay. I mean, if the last 20 years post 9/11 has demonstrated anything in the United States, is wow, do we swing wildly from a period of nothing going on to, oh my goodness, everybody is afraid of X. And then we overreact. And then we're just like, okay, now how do we, how do we go back to normal? Can we go back to normal? And I'm not entirely sure that that's good for a nation, for a people, right? To have that kind of extreme oscillation back and forth. Particularly because, again, a lot of what we're talking about in the context of post 9/11 in responding to terrorism, you can put into a larger context of war, of responding to public health crises, and other kinds of crises. And I wonder if maybe some learning from this could happen. This is me being hopeful, as we're recording this. But you're right. As scholars, as academics, okay, it's a balance.
Cautiously hopeful.
Yes.
Thank you both for working with me with Constitution Day this year and with the anniversary of 9/11. You've given me a lot to think about. I do want to remind our viewers that there will be a link below this video to the webpage that's attached, where there will be references, executive orders that have been mentioned, court cases that have been mentioned. All of that stuff will be linked there if you want to do more research. And we thank you so much for your attention.